5 seconds to go. Start. Mrs. Monica was examined as PW1 and she asserted in her sworn testimony that on the date of incident at about 2 p.m. a quarrel had ensued between the children of two families and therefore Ram Kumar Singh had gone to the house of Kallu Singh with a view to get the matter reconciled amicably, but the deceased was abused him. It is further asserted by her that at about 7 p.m. on May 30, 1983, when she, along with her deceased husband and son Ravi Kumar, was returning from market, they were accosted near the house of Kallu Singh, who was standing on the road in front of his house, and that the appellant, who was having a gun, had fired a shot at the deceased, as a result of which the deceased had fallen down on the road. Though this witness was cross examined searchingly, nothing could be elicited to establish that the appellant and others were falsely implicated in the case because of enmity. Her testimony gets complete corroboration from the contents of FIR lodged by her. The courts below, on appreciation of evidence, have held that the FIR was neither anti-timed nor delayed and that the same was filed promptly. It is well settled that when soon after the occurrence the FIR is lodged at the police station, false story being cooked up or false implication of accused stands ruled out. The testimony of wife of the deceased also gets complete corroboration from the testimony of witness Ravi Kumar, who was examined as PW2. Witness Ravi Kumar has also stated that the appellant had fired a shot from his gun at the deceased, as a result of which the deceased had died. Though this witness was cross examined at length, no dent could be made in the assertion made by him that the deceased had died because of the gunshot fired by the appellant. It is well to remember that Mrs. Monica PW1 is the wife of the deceased, whereas Ravi Kumar is the son of the deceased. They, being the close relatives of the deceased, would not allow the real culprits to go scot free and implicate the appellant falsely in the case. As noticed by the High Court, Kallu Singh was brother in law, that is, husband of the sister of Mrs. Monica. Therefore, she would never make an attempt to implicate the appellant falsely in the case, as the appellant is closely related to her. It was easy for her to mention in her FIR and before the court that the shot was fired either by Kallu Singh, that is, her brother in law, or by Vijay Pal Singh, but she has not made any such attempt and attributed the firing of the shot only to the appellant. The trial court, which had advantage of observing demeanor of the witnesses, has rightly placed reliance on the testimony of Mrs. Monica for the purpose of coming to the conclusion that the appellant had fired a shot at the deceased, due to which the deceased lost his life. It is clear from the above pleadings that in 1990 the state government resolved to resort to special recruitment to the Haryana Civil Service Executive Branch, invoking the proviso to Rule 5 of the rules. Pursuant thereto, it issued the notifications dated December 20, 1990. The names of the candidates were forwarded by the state government to the HPSC for selection. The HPSC commenced the selection process and interviewed certain candidates. In the meantime, on account of an undertaking given by the Advocate General to the High Court at the hearing of CWP number 1201 of 1991 and allied writ petitions, the state government was required to forward the names of the candidate belonging to two other departments of the state government. Before it could do so, the new government came into power and it reviewed the decision of the earlier government and found the criteria evolved by the earlier government unacceptable and also noticed certain infirmities in the matter of forwarding the names of eligible candidates. It therefore resolved to rescind the earlier notifications of December 20, 1990 and January 25, 1991. It will thus be seen that at the time when the writ petition, which has given rise to the present proceedings, was filed, the state government had withdrawn the aforesaid two notifications by the notification dated December 30, 1991. The stage at which the last mentioned notification came to be issued was the stage when the HPSC was still in the process of selecting candidates for appointment by special recruitment. During the pendency of the present proceedings, the state government finalized the criteria for special recruitment by the notification of March 9, 1992. Thus, the HPSC was still in the process of selecting candidates and had yet not completed and finalized the select list, nor had it forwarded the same to the state government for implementation. The candidates, therefore, did not have any right to appointment. There was, therefore, no question of the High Court granting a mandamus or any other writ of the type sought by the appellants. The law in this behalf appears to be well settled. In the state of Haryana versus Subhash Chandra and others, 1974, SCC 165, this court held that the mere fact that certain candidates were selected for appointment to vacancies pursuant to an advertisement did not confer any right to be appointed to the post in question to entitle the selectees to a writ of mandamus or any other writ compelling the authority to make the appointment. In that case, an advertisement was issued stating that there were 50 vacancies in the Haryana Civil Service Judicial Branch. An examination was held by the HPSC and 40 candidates passed the said examination with the required minimum 45% marks. Their names were published in the government gazette. The state government, the appointing authority, made 7 appointments out of the said list in the order of merit. Respondents who ranked 8, 9, and 13 respectively in that list did not get an appointment, although there were vacancies. Stop.